Donald Trump openly charges Barack Obama for criminal conspiracies against him. As we have seen all too often, the whole illegal alien debate always seems to take a turn for the complicated. And that's the way most globalist politicians and organizations such as the American Civil Liberties Union or ACLU want it, so they can fool average Americans into believing the problem is fixed while our nation continues to be invaded by foreign nationals. The ACLU now took it upon itself to once again act in the better interest of the foreign national over the American citizen and was able to coerce the loony Ninth Circuit Court to allow illegal alien detainees held for months, or even years awaiting deportation, to have a bail hearing every 6 months in order to have a venue to challenge their confinement. This ruling is awful for American citizens because if the judge overseeing the proceedings is left-wing activist, chances are that illegal alien will end up free on our streets. Just like what happened in the Kate Steinle case, where she was killed by an illegal who had been in prison multiple times and deported back to Mexico at least 5 times. But this week the Supreme Court decided to rule in favor of the American citizen and against the ACLU and the illegals they harbor and give aid to. Adding to the ruling that the ACLU has forgotten the simple fact that the United States constitutional rights only apply to American citizens, not foreign nationals or illegal alien criminals. All the ACLU was trying to do by bringing up this lawsuit was to create a situation where illegals were protected from deportation, which in turn would give them the privilege to get a bail hearing and go free, only to never be found again. This Supreme Court ruling is a huge victory for all rule of law loving American citizens, and it actually brings us one step closer to fixing this immigration mess caused by years of lawlessness brought on by both political parties. Via the Daily Caller. Immigrants detained for removal proceedings may be held indefinitely and are not entitled to a bail hearing, the Supreme Court ruled Tuesday. The ruling means that immigrant detainees, who are sometimes held for months and years on end, have no recourse to challenge their confinement. Justice Samuel Alito delivered the opinion for the court, joined by Chief Justice John Roberts and Justice Anthony Kennedy. Justices Clarence Thomas and Neil Gorsuch joined most of Alito's opinion, though they also wrote to say they do not believe the court had jurisdiction to hear the case. In a rare move, Justice Stephen Breyer read part of his dissent in the courtroom during Tuesday's proceedings. The justices only read their dissents from the bench when they mean to emphasize their disagreement with the majority. Justices Ruth Bader Ginsburg and Sonia Sotomayor joined his opinion. Justice Elena Kagan was recused because she briefly participated in the case while serving in former President Barack Obama's administration. The Ninth U.S. Circuit Court of Appeals found that individuals held in immigration jails pending deportation may have a hearing every 6 months to review the legitimacy of their detention. The Ninth Circuit based its decision on a legal rule called the canon of constitutional avoidance. The rule says that where a federal law has multiple interpretations, courts must rely on the interpretation that avoids constitutional problems. Alito explained that this approach was mistaken, since the words of the statute clearly do not provide bail hearings for detained immigrants. That is not how the canon of constitutional avoidance works, Alito wrote. Spotting a constitutional issue does not give a court the authority to rewrite a statute as it pleases. The High Court declined to say whether the Constitution requires bond hearings for aliens in detention. They asked the Ninth Circuit to resolve that issue, and may review their determination at some future date. The American Civil Liberties Union represents the immigrants who brought the action. They say detainees are eligible for bail under the Due Process Clause of the Fifth Amendment. In dissent, Breyer made technical and conceptual points. As a definitional matter, he said that the word detain as it appears in the relevant law has sometimes meant simply to restrain. Restraint, he says, could mean subjecting an individual to a number of restrictions, forbidding travel or contact with particular persons, that don't include confinement. Therefore, by his telling, the word detain is consistent with bail. He also said that bail is a basic, and important, component of the Anglo-American legal tradition. The bail questions before us are technical but at heart they are simple, he wrote. We need only recall the words of the Declaration of Independence, In particular its insistence that all men and women have certain unalienable rights, and that among them is the right to liberty.